plaintiffs and the defendants in those 3 or 4 cases all are aware that we're not trying to go back and change the rules on them in the middle of the game. I mean, they engaged in these lawsuits when that was the proper forum for them to be in. And although if these things happened in the future, they would take a different tack. They would go to the administrative law court. And the administrative law court is probably a better forum to handle it. It's, most of these things would not require jury trials, and our administrative law judges do routinely hear environmental-based cases where our circuit court judges hear everything from murder cases to condemnation cases to, people injured in car accident cases to products liability cases. So these judges hear virtually everything and don't necessarily have any environmental expertise, not that they necessarily would need that, but the administrative law judges hear environmental and permit cases all the time.
So this is an improvement from an environmental standpoint?
I think so. The staffs at the law clerks and the staff at the administrative law court is just routinely, they do deal with permitting cases already. So this is not going to be new material for them to have to learn. Otherwise, where it is now, we're taking a judge who knows how to try a death penalty case, or a judge who knows how to try a products liability case where a car manufacturer's vehicle rolls over and was improperly designed or something like that. And those are very medical malpractice cases, very complex cases, but they don't necessarily have any staff or themselves may have never even heard an environmental permitting case, which is sort of a unique situation. So the ones that are there, including the SHEP cases, will continue on because that's the way the rules were set up at the time they were filed. Once the new law takes effect, whenever it passes and the governor signed it, we'll send it to administrative law courts, and I think everybody on both sides agrees that that's probably a better forum to hear those. Also, the timetable, because circuit court judges do hear everything, a case can last in circuit court for up to 2 years, and in the administrative law court, you should be able to get your hearing and decision within more like 6 to 9 months.
Oh, really? Okay.
Yeah.
So there's a little bit more.
So a little bit more expedited procedure and process. The appeal from either one, whether you went to a